Good afternoon and welcome to the Center for American Studies Constitution Day event. My name's Elizabeth Coffer-Bush. I'm co-director of the Center for American Studies here at Christopher Newport. Our mission is to promote education, teaching, and scholarship on America's founding principles and history. Our center was inspired by another institute called the Jack Miller Center, whose namesake was recently awarded the highest honor of the American Legion, the Distinguished Service Medal. I'd like to thank the Jack Miller Center for their support. Each September 17th, Americans commemorate the anniversary of the signing of the Constitution. This recognized holiday requires educational institutions like ours that receive federal funds to hold an educational program on the United States Constitution. The Center for American Studies tradition has been to hold a debate on a controversial issue of public policy to help restore our faith in the power of civil disagreement and civil discourse. Today's topic is, are the current Title IX regulations constitutional? If you will indulge me, I'd like to take a moment or a few moments to introduce our speakers as they're very accomplished. We have Professor and Dean Erin Buzuvis, a law professor at Western New England University, where she has served as Associate Dean for Academic Affairs since 2020. Wow, taken over right during COVID. That's a lot of fun. Dean Buzuvis researches and writes about gender discrimination in education and athletics, and I should say before it became the trendy thing to do. It's really hot right now, but she's been doing this for quite a while, including such topics as Title IX's application to campus disciplinary proceedings for sexual assault, Title IX and college athletics reform, LGBTQ inclusion in high school and college athletics, and retaliation and related discrimination. She has been quoted in stories about Title IX, such as the New York Times, NPR, Sports Illustrated, and Inside Higher Education, and in many other national and local publications. She teaches courses on administrative law, employment discrimination, Title IX towards property, and has also taught courses on LGBTQ policy, as well as a course on gender and human rights in sports, and that was on a grant from the Fulbright Specialist Program. Prior to joining the faculty, she served as an associate attorney. And our second presenter today, or debater. Debate sounds so harsh. We're really doing a civil discourse, but they are debating. They are on separate sides of an issue. They have very strong and passionate opinions. And I hope you're going to see that intelligent people really can disagree with one another and can do so in a meaningful way. So our second speaker today is Alison Somin, a senior legal fellow at the Pacific Legal Foundation since 2020. She serves on the Constitutional Scholarship Team, who focuses on equality and opportunity and the separation of powers. Before joining the Pacific Legal Foundation team, Alison was a special assistant and counsel for over a decade to Gail Heriot, a member of the bipartisan United States Commission on Civil Rights. She has deep roots in the liberty movement. She was an associate at the National Federation for Independent Business Legal Foundation, and during law school completed summer clerkships at the Institution for Justice. And I recently learned her JD is from my alma mater, Emory University, and her BA from Dartmouth. Her work, too, has been published in nationally recognized journals, San Francisco Chronicle, Daily Journal, Texas Journal of Law and Politics, Federalist Society Engagement Magazine, among others. No, I'm not done yet, because I have the honor of introducing our moderator, who I'm about to hand over the events to. We are very fortunate here at Christopher Newport to have the Honorable William C. Mims serve as our pre-law director. He is a former Virginia Supreme Court Justice, former Attorney General for the state of Virginia, and former member of Virginia's General Assembly. He's only the second Virginian in history to serve Virginia's top 3 legal positions. I don't know if you students know this about him, but you should. We have such a great resource here. So he's been involved in making the law, enforcing the law, and interpreting the law, not all at the same time. He previously taught at 2 other Virginia law schools, and he's deeply committed to teaching and mentoring undergraduates. He has lots of things he could be doing, but he chose to be here, and we're grateful for that. So we're going to pass it over to Professor Mims.
Thank you for that introduction. I would point out this is the job that's the most fun that I've ever had also. I want to, having introduced our 2 distinguished speakers, I want to take 1 minute to praise the Constitution on Constitution Day coming up in a few days. As I tell my students, the Constitution as ratified was imperfect and incomplete. Yet as amended, it has permitted America to become great. And it does not give us all the answers. As Joseph Ellis, a distinguished historian, said, the founding generation's greatest legacy is the recognition that argument itself is the answer. Which brings us to today's debate, which won't be an argument. You all saw an argument on Tuesday. This is a real debate between distinguished scholars. It may not be as consequential as Tuesday. It may not have 27 million people, although this is an impressive turnout, by the way, but it will be more substantive. And Title IX fascinates me personally because it passed the Congress in 1972. The intercollegiate sports was added just a couple of years after that. That's when most people became familiar with it. And I actually heard on a WNBA broadcast earlier this week, Title IX mentioned. It's a great quote. Without Title IX, you don't get Caitlin Clark and Angel Reese. I can't say it better myself. That's not the most controversial aspect of Title IX, and we will get into some of the controversy during this debate. So each of the participants will take 15 to 20 minutes to speak about their position, and then each will have 5 minutes of rebuttal, and then we'll have question and answer for the remainder of the time. Dean Buzuvis, if you would go first.
All right. Well, I have a few slides because as part of my argument, I'm going to also incorporate some Title IX history and background. And as you just heard, one of the, obviously the key milestone in Title IX was its passage in 1972. Congress passes a very brief statute as part of another comprehensive educational overhaul that stated no person in the United States shall on the basis of sex be excluded from participation in or otherwise discriminated against by an education program receiving federal funds. Very simple, right? Now we all know what sex discrimination means and we can all go home. Well, no, the story continues. As happens with many statutes, because we have 3 branches of government, we have a system where they all work together to help refine, clarify, interpret, and implement the law. So the next step in Title IX's journey was getting kicked over to an executive branch agency called Health, Education, and Welfare. This is the predecessor agency to today's Department of Education, which has authority over Title IX right now. Hugh had the responsibility to promulgate some implementing regulations. And as you heard, a lot of those regulations had to do with athletics. And those regulations addressed sex discrimination in admissions and things like scholarships and employment discrimination in the context of education, so a wide variety of topics. But one of those provisions of the Title IX regulations said that schools that are subject to Title IX have to create a procedure to resolve disputes about sex discrimination. And so that would include any kind of disciplinary matter coming up under Title IX. So all of this is still pretty vague and operating at kind of a big picture level. Around the same time, the courts start considering laws like Title IX, but not only Title IX, because there are other civil rights laws that prohibit discrimination on the basis of sex, mainly Title VII, which applies in the context of employment. Plaintiffs started arguing and courts started accepting that sexual harassment is is a subset of sex discrimination. And as that happened, it caused some questions in the Title IX context. So if schools have this responsibility under the 1975 regulations to promulgate a disciplinary proceeding to handle disputes about sex discrimination, now we know those disputes need to also include disputes about sexual harassment. So one student accusing another of sexual harassment. So the Department of Education responds over the years with increasingly more detailed clarifications of what those disciplinary proceedings need to look like. But the most detailed clarification came in 2011 in the form of a Dear Colleague letter. So this is not the formality of an official regulation, but something that said, hey, remember that regulatory provision that says you have to have prompt and equitable responses to inter-student disputes about sex discrimination, and you already know that those include sexual harassment and similar types of disputes. Please know that now we're going to add some increasing detail to that. What does it mean to be prompt? What does it mean to be equitable? Promptness, the Dear Colleague letter said, generally speaking, you should be resolving these disputes within 60 days because we've heard some things that a number of you universities are trying to run out the clock and take so long that a person who's accusing another of sexual misconduct ends up graduating before any relief is issued. And so let's tighten up the reins on those proceedings so that they happen more quickly. And what do we mean by equitable? Well, the Department of Education says we've also heard some things about you universities doing things like giving the accused student so many procedural protections that it operates in such a way that you can never discipline a student for sexual misconduct. And there have been some cases where high-profile students, such as a star athlete or son of a wealthy donor, is getting away with sexual misconduct because it looks like the deck is stacked against them procedurally. So the Dear Colleague letter spells out how procedural rights need to be equally distributed between the student who's complaining about sexual harassment and the student who's being accused. Well, this Dear Colleague letter in 2011 sparks a lot of concern and backlash. In fact, it's the reason why I was invited here 9 years ago to be a Constitution Day debater. So I've been here before talking about the subject, but my timeline was a lot shorter back then because this was where the story picked up then, and we debated the controversial nature of the Dear Colleague letter provisions. So the Dear Colleague letter, like I said, 2011, that was during the Obama administration. Now, you all know what happened politically. The next president to get elected is President Trump, and the Trump administration does not like the Obama administration's interpretation of Title IX. And here I am admittedly cutting a long story short to give the character of the Trump administration regulations on this point of how much procedural protection students accused of sexual misconduct should have. And the Trump administration says they need to have the kinds of constitutional protections that you would see, the kinds of procedural protections that you would see in a criminal trial, the kinds of procedural protections that make it way more difficult to subject somebody to discipline for sexual misconduct. Well, as we see in administrative law, as we see in politics, a change in administration can see policy yo-yo back and forth between ideas from the right and ideas from the left. So you guessed it, when the Biden administration takes over, one of their first orders of business for education policy is to amend the Trump administration rule, right, which was itself a reaction to the Obama era letter, to restore some of the equal playing field of procedural rights between parties to a dispute regarding sexual misconduct. But that's not all the regulation did. The regulation does a number of other things. It enhances protection for students who are parenting or students who are pregnant, and it extends our understanding of what sex discrimination is under Title IX in the form of a regulation, not to the extent that this hasn't already been said by courts and even by the Department of Education in other documents. But for the first time, a Title IX regulation now says that sex discrimination includes discrimination on the basis of gender identity. And that provision is meant to protect trans students from discrimination and harassment. And that's the provision that ends up being targeted for litigation. So over the summer, while this rule is pending and being getting ready to take effect, in a number of separate litigation, several attorneys general from red states band together with some right-wing special interest groups and sue the Department of Education, seeking an injunction of the rule. What they want is for a court to say that the rule cannot take effect. And a number of these cases were successful, such that when the rule's implementation date, April 1st, came, the rule was not able to take effect nationwide. In fact, in a number of states, the rule itself has been prevented from taking effect, and the remedy that the courts gave to the plaintiffs who were seeking a preliminary injunction also extended to the members of the organizations that had joined that litigation, any school where the children of those members were attending. And so as a result, not only the states that have sued to challenge the rule, but universities across the country, thousands of them, including yours and mine, are subject to this injunction, and the rule cannot take effect here because of this litigation. Now, a preliminary injunction is just that, preliminary. So what it means is now there's litigation on the merits, and a court will go back and say, okay, now we're going to use a different standard. We're not just anticipating likelihood of success on the merits, we're actually going to consider the merits. A decision on that would then probably be appealed up through the federal appellate courts before we finally get an answer on the constitutionality of Title IX. But that's the background. I want to next talk about what some of the particular regarding the aspect of the rule that is controversial, that has engendered the litigation against it, the provision that extends sex discrimination protection to transgender students. The objection that we hear most frequently from the litigants who are challenging the rule is that this regulation is going to inhibit free speech in schools. That if a federal civil rights law says that you cannot discriminate against trans students, that's going to mean that we can't say what we mean and say what we believe about transgender students. So that claim conflicts with precedent from courts on two different strains of thought, and I'm going to illustrate them here. First, we have a long judicial history of recognizing harassment as a subset of discrimination. And so we have cases, and here I've color-coded the case names here, where the darker the court, the higher the court is in the hierarchy. So the darkest green cases are our Supreme Court cases, the light green ones are district court cases. But this is just to show you that going back, not quite as far as Title IX, but for a long time, we've seen courts recognizing that harassment is a legitimate subset of sex discrimination, even though Title IX itself doesn't say anything about harassment. And one of the most important cases in this trajectory is the last one, Davis versus Monroe County, because this is the case where the court gives us a standard that says when harassment meets these particular criteria, it is actionable under Title IX. And it's important that that comes from the Supreme Court, because that's the Supreme Court acknowledging that it's legitimate for civil rights laws to prohibit sex discrimination and to prohibit sexual harassment. So now separately, we have a line of cases that also recognizes that transgender-based discrimination is a subset of sex discrimination. So here we have just a collection of, these are by no means all of the cases. I included one from Tuesday just because it was from Tuesday, but there could be any number of district court cases sort of in the recent past that have regarded transgender discrimination as a subset of sex discrimination. But notice that we also have a Supreme Court case acknowledging this relationship between sex discrimination and discrimination against trans people. So I want to explain what the Supreme Court was talking about when it was articulating this relationship. So the Supreme Court says that discrimination against transgender people is an aspect of sex discrimination by using something that courts use all the time when they're trying to identify discrimination. It's called a substitution test. So if you're looking for sex discrimination and you have a case and you say, okay, the person who's challenging this action against them, whether it's they were fired from their job or they didn't get into a certain school or their school failed to take sexual or harassment against them seriously, if you could imagine that this plaintiff was of the other sex and the result wouldn't have been the same, then you have discrimination because of sex, right? If you hold everything else constant and you only change the sex of the plaintiff, then you have sex discrimination. So in the Bostock decision in 2020, the Supreme Court did this in an employment discrimination case, and it looks like this if you like a visual diagram. Right? If you have a plaintiff who's a transgender woman, that means that she's assigned male at birth and that she identifies as female. And let's say that a school or an employer takes an adverse action against her because she's transgender. Now, if you're going to use the sex discrimination substitution test like courts often do, you imagine as a hypothetical counterpart a cisgender woman who is assigned female at birth and who identifies as female, and you ask, does she also receive the same adverse treatment? And if that answer is no, then you have sex discrimination proven by the substitution test. Everyone see how that works? If that trans woman's assigned sex at birth was flipped from male to female, she would be in the category of people not receiving adverse treatment. So the court says sex discrimination includes trans discrimination. It doesn't require us to reimagine what Congress might have been thinking when it passed these civil rights laws in the 60s and 70s. It doesn't matter that they didn't have trans people at the front of their mind, or that there's nothing in the legislative record about trying to protect trans people. Congress used the word sex discrimination, and that is meant to encompass every type of sex discrimination, including where the substitution test works in the way that we have here. Okay, so the argument that harassment against trans people violates the Constitution conflicts with this acknowledged history by the Supreme Court. The Supreme Court has acknowledged in cases like Davis that harassment can be covered legitimately by civil rights laws without causing First Amendment problems because of the standard that is used to define sexual harassment. And so here's some additional language from the Title IX rule itself. First, at the top, you can see the text that demonstrates the newly implemented definition of sex discrimination, and how the Department of Education is saying that discrimination on the basis of not only sex, but sex stereotypes, sex characteristics, sexual orientation, and gender identity are covered. And then I've also excerpted the aspect of the regulation that talks about the harassment covered by Title IX. The requirements for harassment to be actionable under Title IX, it has to be sex-based, right? See the list above. It has to be targeting somebody based on one of those characteristics. It has to be both subjectively and objectively offensive. And what does that mean? Subjectively offensive means you called me a name and I'm offended. Objectively offensive means, and we would all agree that that's offensive. offensive, right? Even if I'm a thin-skinned outlier, the Title IX regulations don't kick in unless it's pretty clear that a reasonable outsider would look at that situation and say, yeah, that's offensive. Actionable harassment also has to be severe or pervasive. Why or? Severe sexual harassment might be something like sexual assault or rape. Well, in the Trump-era regulations, the or was replaced with an and, such that severe harassment also had to be pervasive in order for it to be actionable under Title IX. So how many rapes until a school's obligation to respond kicks in? That interpretation of sexual harassment, of the sexual harassment framework, conflicted with decades of harassment law from outside the Title IX context as well as within it. So the Biden-era rule restores the or, severe or pervasive. So pervasive harassment means a one-off comment. You accidentally misgender someone, you use their wrong name, or even if you do it intentionally, one time, it is not actionable sexual harassment. It doesn't become sexual harassment for purposes of Title IX until a level of pervasivity has occurred. And how pervasive does it have to be? It has to be so pervasive that, see the last item, it operates to limit someone's ability to attend school in some way. So a reasonable person would say, gosh, someone who's being constantly harassed by another person in the class or by the professor in the class, yeah, we can see why they would need to switch their class at this point. Like, that is a hostile environment that no person could be reasonably expected to endure. And that is a limitation on a student's federally protected right to education that makes it actionable for under Title IX. So why do I emphasize these limitations? Because this is the crux of the First Amendment argument, that people are going to be hamstrung in their ability to speak their mind about trans issues. But the only language, the only type of the only words that are subject to Title IX are words of harassment that meet these particular characteristics and qualifications, right? Objectively offensive, meeting a level of severity or pervasivity that actually drives someone out of the class by any reasonable standard. I think when you encounter arguments about Title IX going too far and invading the academic freedom of professors or invading the academic freedom of students to say what they want in class, I want you to keep these limitations in mind. I also want you to do one other thing, which is another substitution test, but a different type of substitution test. Ask yourself if the harassment that was being challenged was against any other person with a constitutionally protected identity. Would there be First Amendment objections? Courts have considered the constitutionality of the harassment standard here in other contexts. In the sexual harassment context, a college woman gets hit on by her TA. She says, please don't do this, I'm not interested in you. And he persists. He writes her love letters. He speaks to her all the time, tells her how much he loves her, tells her how much she wants to be with her. She says, no, please stop doing this, please stop doing this. Eventually she changes her class, because of course she would. That's uncomfortable. She sues. He says, I have a First Amendment right to say whatever I want. And the court says, that doesn't mean you have a right to harass someone. Right? So we have limits on free speech. The First Amendment doesn't protect all speech, and the First Amendment has been regarded not to protect harassing speech. And we regard that in the context of sexual harassment. Imagine a case about racial harassment. Imagine that you have a professor at a public university who, for religious reasons, doesn't believe that interracial relationships are valid or should exist. And he has a student in his class, a female student, who's white. And he refuses to call her by her married last name because her married last name is that of her black husband. And let's say that he persistently, pervasively calls her by her wrong name, her disfavored original name, instead of by her married name, in front of the whole class every time he calls on her. And he won't change. And she asks him, please call me by my married name, and he says no. And everybody knows that the reason why he's doing that is because he has an objection to her marriage. Would we accept that as an example of free speech that should be protected and tolerated in a public school? If that were your friend, wouldn't you accompany her to the administration to complain that something should be done and a professor should not be able to humiliate and single out a student in class for, especially for any reason, but for reasons that are related to a constitutionally protected identity?
Dean.
So when we accept this in the context of transgender rights, we are perhaps, when we don't accept this in the context of transgender rights, a double standard has emerged. Am I out of time?
Yeah, I have to smile because your example is very powerful. But if I were a justice at this moment, I would say, counsel, thank you for your example, but that your time has expired. I've never said that to a dean on a college campus before.
I apologize. I've had a stopwatch, and it failed me. Thank you for the interruption. That's all I have to say.
All right. So now, Ms. Somin, now the microphone is yours. Thank you very much.
Thank you for the kind introduction and for the invitation to this debate and to Christopher Newport University. I'm sorry, was there a microphone issue? Okay, thank you. I'm enjoying my first time here in Newport News, Virginia. What I want to focus on today is what I see as three constitutional areas of concern with the most recent round of Title IX rulemaking. I appreciate Professor Buzuvis' setting up carefully the background on this rule and also the historical background that led through many rounds of rulemaking to this particular rule. What I want to be clear that I'm not here to talk about what policies schools should adopt regarding sexual orientation or gender identity. Norms are evolving, public opinion is changing, medical and psychological research on these topics is ever changing. I don't purport to know when and where it's going to settle. What I am here to say, whatever you think the policy should be, Title IX is not the right vehicle for addressing this problem. As Dr. Buzuvis indicated in her opening remarks, this is a 1972 statute that was enacted for quite a different purpose. It was enacted at the height of second-wave feminism to stomp out sex discrimination. Its drafters were mostly thinking about discrimination against women, but they wrote the statute in a sex-neutral way, and so it prohibits all discrimination based on sex. As Dr. Buzuvis said a few moments ago, a lot of what's in this particular rule is relatively non-controversial. It's over 1,500 pages long. There are parts of it that simply recapitulate the content of earlier rules or add only minor glosses. There are also issues addressed that haven't gotten much attention in the press, like rules regarding pregnancy and parenting. Nonetheless, I see three real areas of constitutional concern about this rule that have given rise to litigation that was discussed earlier. Today, I'm going to focus on three of them: First Amendment and freedom of expression concerns, due process concerns, and finally, separation of powers problems. The First Amendment, as was alluded to earlier, protects our individual right to free speech. The Supreme Court has tried, in delineating harassment cases before, has indicated that there's this inverse relationship between severe and pervasive harassment. You heard a little bit about that earlier. The problem with redefining harassment broadly in this particular rule, switching back to the severe or pervasive requirement, is that it's going to leave vulnerable a lot of free speech on campus, not just speech that targets an individual person in a derogatory manner, but speech about core political and social issues. We have abundant anecdotes that under earlier versions of the rule that defined harassment in a broad way, this was a problem. Take, for example, the plight of Laura Kipnis, a film and gender studies professor at Northwestern University. She published an essay in the Chronicle of Higher Education called Sexual Paranoia Strikes Academe, claiming in the post-Title IX landscape, sexual panic rules, and that if you want to produce a pacified, cowering citizenry, this would be the method. Although such speech about political issues is pretty clearly within the heartland of the First Amendment, Kipnis underwent multiple Title IX investigations. They dragged out for months before she was finally cleared by her university of all wrongdoing. Another example. In my professional life, I mentored an intern who'd faced a Title IX investigation at his university, Yale University. He'd written a paper about Plato in which he criticized Plato's tripartite theory of the soul. Plato has a passage about how the appetite can become allied with the spirit against reason, and he used rape as an example of a circumstance in which this philosophical theory didn't seem to hold water. Again, this wasn't targeting anybody in particular. He was expounding on a broad philosophical issue. He was dragged before his university's Title IX office, finally had to retain a lawyer and reach a settlement with the university before his name was cleared of all wrongdoing, and he could achieve his dream of applying to law school with a clear record on this front. Reinterpreting Title IX to cover sexual orientation and gender identity is just going to create new First Amendment tensions. Some examples that we've already seen that are now in litigation. Michael Stannard, a professor in California's State Center Community College District, faced investigation from his university because he said in class that, quote, student studies show children do better if they are raised by both parents. Another California community college professor in the same system as Professor Stannard also faced a Title IX investigation because he satirically listed the musical phrase do, re, mi as his pronouns on his Zoom profile. Professor Buzuvis has talked a little bit about the severe pervasive relationship, tried to make it show that typically examples of speech like this, when they're not very severe, they're not very pervasive, they're not accompanied by physical conduct, should be safe, they should be fine. In theory, I agree, these should be fine. I think one of the reasons why these people keep getting dragged into these long drawn investigations is because some inherent ambiguity in the severe and pervasive standard. A university never quite knows when pervasive is hit. It's inherently ambiguous and subjective. So for the typical Title IX office, the smart thing to do is to take even the most insignificant report hyper seriously and really run it to the ground until you're sure that nothing's happened. The problem is this can put someone like my friend, the young intern, like Professor Kipnis, through months and years of investigation, often at great personal expense and great stress, before his or her name is finally cleared. I don't think that's okay morally. I don't think it should be okay legally or under our Constitution. Turning now to the due process issues. As was stated earlier, there was a push in the Obama administration to crack down on sexual harassment and assault on campus. This was a worthy goal, but the problem is that the guidance that was issued under that administration and the fear of investigation from the Department of Education was leading all too many colleges and universities to skimp on due process in investigating these allegations of misconduct. What's due process? This is a concept that refers not to the what of legal proceedings, but to the how. Does each side get a fair opportunity to tell its side of the story? For non-lawyers, you'll often encounter this basic concept the first time through the criminal trials you see on TV or in the movies. You learn about the right of the accused to testify, the right of the accused to confront his accuser, and so on. In the civil context, or in the context of a university investigating a student, there's a need for fewer and less elaborate rules because less is at stake. I agree with that. Still, the Supreme Court has consistently recognized that even in school proceedings, there's a need for some level of basic due process. What were some due process problems under the earlier guidance that have come back with this new rule? The new rule eliminates the rights of student respondents in sexual misconduct cases to live hearings, to inspect evidence against them, and to have legal counsel present. Schools may use a single investigator to serve essentially as both a prosecutor and judge in Title IX cases, and schools can launch Title IX investigations without a formal written complaint. The last time around, due process deficits such as these had significant real-world impacts. The Foundation for Individual Rights and Expression, a nonprofit, at one point counted more than 600 lawsuits by students accused of sexual misconduct under these rules. A couple years back, I read a book by Alexandra Brodsky. She's a progressive advocate. She and I don't really agree on Title IX issues. I thought it was interesting as I was reading and reviewing her book that she documented cases of students in universities where due process was so bare bones that even she conceded that things had gone seriously off the rails. One anecdote that stands out in my mind here, she tells the story of a young man whose first name was Brandon, a pseudonym that she used. He was found responsible for sexual assault based on the findings of a single investigator without a hearing. She described being genuinely shocked by the lack of detail in this report and the poor level of analysis. Eventually, Brandon did clear his name, but only after hiring a lawyer at great personal expense. Finally, I want to talk about what I see as the separation of powers problems with this rule. The Constitution vests all legislative power in Congress. The agencies that enforce the laws written by Congress are inevitably going to fill in some minor gaps left by the legislature, but this gap-filling authority does not allow agencies to invent new rights or duties only vaguely hinted at in their authorizing statutes. If a statute really is broad enough to grant an agency power to make up new obligations, then Congress has improperly delegated its legislative authority, and that's what's known as the non-delegation doctrine. The Constitution's framers believed that a republic, a government of the people, would be more likely to enact just laws than a regime administered by a ruling class of ministers. Not only should all power be derived from the people, as James Madison wrote in Federalist No. 37, but those entrusted with it should ultimately be kept in dependence on the people. The non-delegation doctrine protects individual liberty by prohibiting Congress from delegating its lawmaking authority to administrative agencies. It requires that Congress must lay down an intelligible principle to which regulated parties must conform. If a law is so vague that it does not lay down an intelligible principle and essentially gives a federal agency a blank check to do whatever it wants, then Congress has unlawfully delegated its power. The non-delegations doctrine's finest moment came in the 1930s when the Supreme Court struck down 2 New Deal regulatory codes as violations. But it's far from dead. In Gundy versus United States, a 2019 case, all justices agree that the non-delegation doctrine would apply if the statute at issue gave the Department of Justice the unguided and unchecked authority that petitioner Gundy said it did. Gundy lost ultimately because a plurality of justices interpreted the statute to give the Department of Justice more limited authority. In other words, the justices disagreed on how to read this particular law, but not on the background separation of powers principles that apply in cases involving a grant of virtually unlimited authority to a federal agency. So does Title IX pose non-delegation problems? Reading sex broadly enough to encompass gender identity and sexual orientation, as some of the lawsuits challenging the rule have claimed, would significantly shift lawmaking power away from Congress' Department of Education. It would also likely further limit speech and expression. If a court strikes down this rule based on non-delegation grounds, that will help safeguard individual rights for administrative power grabs, not just in this context, but in future issues involving overreaching agencies. Another separation of powers doctrine that's in play involving this rule, the major questions doctrine. The major questions doctrine evolved in response to the problem of agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. A major question is present when an agency purports to discover an unheralded power representing a transformative expansion in its regulatory authority in the vague language of a long extant statute. When a statute authorizes a federal agency to act, an important interpretive question is, did Congress authorize that agency to act? In some such cases, the history and breadth of the authority that the agency has asserted and the agency's economic and political significance provide a reason to hesitate before concluding that Congress intended to confer such authority. Agencies have only those powers given to them by Congress. and enabling legislation is, as the Supreme Court has put it, generally not an open book to which an agency can add pages and change the plot line. Or, said another way, Congress generally does not hide elephants in mouse holes. Like the non-delegation doctrine, the major questions doctrine protects individual liberty, requiring Congress to speak clearly when legislating on questions of economic and political significance prevents agency overreach and the incursions on individual freedom that come from agencies overreaching. So does the new Title IX rule speak to major questions? For decades, as was suggested earlier, Title IX was understood and not to cover sexual orientation or gender identity discrimination. OCR didn't mention the possibility, and then only obliquely, until a 2010 guidance on harassment. It didn't even articulate fully this policy position for a few more years. When the new presidential administration arrived in 2017, it changed course and stopped interpreting Title IX to cover these forms of discrimination. This history indicates that a major question is present. The rule is also politically significant. State and local legislation about sexual orientation and gender identity questions has been controversial and hotly debated across the country everywhere where it's come up. It's hard to see how a federal rule requiring funding recipients to treat individuals in line with their gender identity when it conflicts with their sex could be viewed as politically insignificant. Well, what about Bostock? Doesn't that case foreclose all of this? Well, I would say to that, not so fast. Bostock was about a different statute, Title VII of the Civil Rights Act of 1964. It's not about Title IX. Those statutes are very similar in some ways. They both prohibit discrimination on the basis of sex. But Title IX is written differently. It contains a lot of exceptions to the general prohibition on sex discrimination that make it clear that the drafters had a binary understanding of sex in place. It talks about one sex versus the other. It doesn't talk about sex in such a sprawling way so that it could cover gender identity. Second, in that case, Bostock, the justices were very clear about what they were doing and not doing. They specifically said that the analysis in that case was limited to facts like those found in that case involving somebody being fired from his place of work because of the individual's gender identity. Bostock was made clear that it wasn't intended to extend to situations like the conflicts commonly seen in schools, where bathrooms, locker rooms, sports teams, those kinds of issues are in play. The court specifically reserved those issues for future cases. Finally, the major questions doctrine applies to rules issued by agencies. It wouldn't have applied in a case involving private litigants like Bostock. So thoughts in conclusion. The Department of Education's new Title IX rule poses numerous potential problems for individual freedom. It will deny due process to students accused of sexual misconduct and, if fully adopted, will also harm free speech and expression on campus. That the rule now extends to sexual orientation and gender identity discrimination will only compound the already extant tension between Title IX sexual harassment law and the First Amendment. But the separation of powers doctrines that exist to protect individual liberty may serve as swords against agency overreach. Multiple lawsuits have already filed on these grounds, and they've been successful in getting preliminary relief against this broadly reaching rule. If they succeed, ultimately, they'll protect student freedoms from Department of Education bureaucrats. Reasonable people can and do have different opinions on how to respond to sexual misconduct on campus and to sexual orientation and gender identity issues. But under current law, it's not the Department of Education's job to settle these debates unilaterally. The Constitution requires that these issues be decided within Congress, our most democratic branch. Thank you.
Dean Buzuvis, you have 5 minutes for rebuttal, and I would ask, would you spend at least one of your minutes addressing specifically non-delegation and major questions from the perspective of the Supreme Court putting those into a much narrower box than they were 5 years ago? How would you respond if you were in front of the U.S. Supreme Court on those questions today? Thank you.
Could we do our rebuttals just from here?
Oh, sure, yes, yes.
No. Okay, sure. So yeah, I'll start with that. And yes, I'm an administrative law professor. I teach about the non-delegation doctrine, and what I teach my students is that Congress is limited in its delegatory powers. It can't just completely turn over an issue to another branch of government and say, here, you deal with it. It has to give some kind of intelligible principle, some kind of general outline. Here's what it is that you have to do. But that general outline can be pretty general, like go forth and make some environmental regulations that protect the public welfare within an adequate margin of safety. That's pretty broad, and that's been upheld as consistent with the non-delegation doctrine. So here we have more than intelligible principle. We have, here you go, agency, you have to create regulations that implement a ban on sex discrimination, right? That's narrower than in the interest of the public within an adequate margin of safety. That's giving some pretty specific context to what it is the Department of Education has to do. And then to say that and then on top of that, it's relevant that the Department of Education has reached the same interpretation that the Supreme Court already has reached. Now, I agree, it's not one is not directly operative on the other. Bostock is not directly relevant on the Department of Education on this question. But to say that it's so outlandish that the Department of Education would come up with this completely outlier idea that gender identity-based discrimination is a subset of sex discrimination, when the Supreme Court has already said that very thing itself, of course one is within the scope of the other, and the very broad and permissive non-delegation doctrine is not at play here. I think there would be great concern if it were that everything else about Title IX would be under scrutiny. Remember, Title IX doesn't say anything specific about sexual harassment either. Sexual harassment as a concept had not developed at the time that Title IX was written, and yet we accept that Title IX regulations validly cover sexual harassment. So laws are allowed to expand from what Congress originally might have had in mind based on as long as they stick within the words that Congress uses. And if Congress is using the word sex discrimination, then the meaning of sex, i.e. to include gender identity, and the meaning of discrimination, i.e. to include gender identity-based discrimination, is relevant and within the scope, the proper scope of the Department of Education's powers. But I also want to rebut some of the arguments on the First Amendment line of thinking about how these regulations are going to cause people to be subject to investigations for their speech. And investigations was the word that my co-presenter used. She didn't have an example of anyone who had actually been punished because of speech that they used. And I get it. I'm a professor. If somebody investigated me, that would be pretty annoying. But I also just want to put that up against what is at stake. Title IX is not just a rule that applies in colleges and universities. Title IX applies K through 12 as well. And a rule that prohibits harassment of kids who are trans is a literally life-saving provision. 68% of all LGBT kids claim in surveys that they have experienced verbal harassment in schools. Okay, and that's just experienced verbal harassment. Now, of those kids, a quarter of those who are transgender have described a level of harassment against them in schools that has driven them to consider seriously thoughts of suicide. That is 4 times higher than the rate of suicidal thoughts among kids in general. What's more, it is proven that when schools are affirming, when schools are supportive of trans kids' identities, that number comes down to the same level as any other type of student. So we can talk about this as, oh, this is a political issue that reasonable minds can disagree and we ought to debate it. We're debating something that is actually putting some people's very existence on the line. And that is something that deserves great consideration and great weight. And in my opinion, more weight than the inconvenience of a professor who might have to clear their name, and who does get to clear their name in the course of a few months of an investigatory hearing. So with that, there's my 5 minutes. I'll leave it at that.
And Ms. Somin, I guess classically this would be Sir rebuttal, but you now have 5 minutes as well to complete the presentations.
Thank you. On non-delegation doctrine, I agree that it's broad. I think that this is an area in which the Supreme Court has recognized the dangers that come with vesting such broad powers in agencies and have been rethinking some of those older cases. I'm glad they're doing that. I think that interpreting non-delegation doctrine is essentially no constraint at all was a mistake. And so I think that this type of issue is a good opportunity to revisit that. And the success of some of these lawsuits in earlier courts suggest that many judges in the lower courts are looking at this and thinking the same way, that the Supreme Court is willing to allow this rule to stay paused is also some early indication of where they are.
Can you put the microphone?
Okay, can you hear me now? Yeah. All right. Okay, thank you. Were you able to hear me a moment ago, or should I? Okay, all right. Then I can briefly move to the First Amendment. I hate to minimize cases where somebody has gone through a long, expensive, and ruinous investigation just because they were ultimately cleared. Another issue in the First Amendment context, it's easier for plaintiffs to bring a First Amendment case in court than in some other contexts because of what's known as the chilling effect. If a decision maker inhibits somebody's ability to speak, most of the time people aren't just going to say, okay, I will speak my mind anyway and see where the chips are going to fall. I will be quiet. And when people are being chilled for speaking their mind on important issues of political, philosophical, social significance, because of concern about Title IX investigation, that is a real cost. And this is a real problem with these rules. And I would encourage rethinking and reforming these rules, and when necessary, striking down overbroad language as a violation of the First Amendment. Thank you.
This has been wonderful. As I said at the beginning, on Tuesday, you did not hear a debate. It was great theater, and we learned a lot. This is a debate, and this is the way it ought to be, and I want you to give another round of applause to both speakers for what they've done. In less than an hour, you have heard about separation of powers, judicial review, major questions doctrine, non-delegation doctrine. One major structural issue that neither of you mentioned but is present in the litigation is federalism. The Attorneys General litigation argues that this conflicts with state law that should be respected in this area. Would each of you speak very briefly to that question, if you choose to?
On federalism, and so I hesitate to wade into the nitty-gritty. I will just say that it's important. There's a tradition in this country, rightly, of allowing state and local governments to regulate in the field of education. We respect the idea that state and local government will often make different decisions from one another, and that there's value in letting the states and localities be laboratories of democracy. I hope the courts take federalism arguments seriously, because I think that they're an important part of our constitutional tradition.
Okay.
I'll strike out an extreme position here. There is absolutely no federalism at stake in this dispute about Title IX, because Title IX is not mandatory. Title IX only applies to schools that accept federal funds, and if you don't want to comply, you don't have to take the money. So if you are a school in a state that has conflicting laws, that's fine. Follow those state laws, but don't do it with federal tax dollars.
Okay. Questions? Raise your hand, and I will call on you. You'll have to speak up loudly. I don't think we have microphones here, or there are. Oh, good. Microphone right here in front. Go ahead. Any questions?
So you mentioned that you don't believe that Title IX is the correct area to speak on LGBT issues and discrimination laws. Do you want to encourage a different law or put it in somewhere else, or not encourage that kind of lack of discrimination at all? Or what would you consider to be the better answer if Title IX is not the answer?
So I think there are a lot of different avenues open to reform. I want to be careful because my nonprofit law firm hasn't staken out an official position on this. In many blue states, protections akin to what's put forth in the current Title IX rule exist, and so the adoption of this rule doesn't change the situation. Same thing in local governments, particularly in bluer areas. Congress could also adopt some version of this rule, and then it could fully debate what kind of provisions it wants to put in place. I think it's better for Congress to do that following a real legislative process than for the Department of Education to just do this unilaterally, putting into place a 50-year-old law that was really adopted for quite different purposes.
Well, I mean, certainly Congress could do that, but I mean, I'll just add, because it's a debate, that Congress has been aware of decades worth of court decisions that have held transgender discrimination as a subset of sex discrimination. So if Congress didn't like that, Congress could have acted at that point to say, this is not at all the way we want to go, right? And so in not doing that, there is potentially, then the question is, why would Congress add another law if Congress has essentially assented to the interpretation of Title IX and other sex discrimination laws as already being interpreted in this way?
Okay, thank you. Other questions?
Yeah, so in the field of administrative law, the standards for what's considered due process are generally lower than for criminal law as a way of encouraging complainants to come forward. So given that, what is the proper balance between ensuring complainants feel comfortable coming forward and the respondents still have due process rights?
I agree that there's some tension there. I think that the 2020 rule that was put into place by the prior administration did a pretty good job at identifying both legally and from a policy perspective how to balance off those trade-offs.
I mean, and of course I disagree. That's why we're here. So I take the position that when you're talking about due process exists on a sliding scale. That protections are highest when the stakes are highest. And that's why they're the highest in the criminal context, because you could be subjecting somebody to imprisonment, loss of liberty. You could even be subjecting themselves to loss of life. And those are the two most important rights that we have. Being suspended from school is serious, but on a spectrum, it is not that serious. So there should be different considerations made to countervailing considerations. And one of the countervailing considerations that the Obama and Biden administrations took into account was making it possible for people who have experienced sexual violence, sexual misconduct, having the ability to come forward. Being cross-examined is a surefire way of chilling reports of sexual assault. That is proven. So what both the Biden and Obama rules try to do is create alternatives to that cross-examined situation while still respecting the right of the respondent to be able to give their say. And to give their say, in administrative law, we have a wide variety of hearings that are not always live courtroom-type proceedings. And so there is such thing as a civil rights model where the new regs insist on professional training and non-biased training, can interview both parties, get both parties' sides, get a unified report that both parties then get to review, and then present that report to a decision maker rather than having both parties dispute about the facts in the context of a live hearing. So having that be an option on the table for schools to use is something that the new reg did that the old reg didn't. And so that's where, those are the kinds of things that I think reflect that better balance that recognizes that the stakes are not criminal stakes here.
I think that there are serious issues with the single investigator model. I mean, if you imagine a criminal or civil proceeding where the judge and the prosecutor are the same person, you can quickly imagine where institutional biases are likely to creep in. In the Title IX world, oftentimes the person who's a single investigator has biases in one direction toward the institution or toward complainants. This was a significant problem. Many people felt that they'd been treated unfairly. I'm not keen on allowing that model to stand into place. I think it creates serious due process problems.
Other questions? We've been talking about due process and and particularly the chilling effect that Ms. Somin, that you mentioned. When someone is required or chooses to retain an attorney, either because they are the complainant or because they are the respondent, when or if are attorney's fees awarded, and at what stage?
I'm not aware that they routinely are.
So you actually have to get into federal court and then make that argument?
I'm not sure, but that may be right.
Is that?
That sounds right to me too, yeah. It's certainly not in at the institutional proceeding. Title IX doesn't require schools to have cost shifting provisions in place.
Okay.
So it would be however it applies in the federal courts.
That's right.
Okay. Procedurally, where does this litigation sit right now from the trial to the Court of Appeals to the certiorari stage? When might we, knowing we will see the Supreme Court,
Right.
when might we see the Supreme Court?
By my count, I think there are 10 lawsuits involving 26 states and a handful of nonprofit groups. The rules stayed from going into effect, and I think, is it in all 26 of them?
Yeah, 20.
And so it's all 10 of these are winding their way through the justice system on their own path. And I think it's likely one of them will get up to the Supreme Court sooner or later, but it's
right.
When.
Right. And there was a moment when the Supreme Court had to touch this litigation,
right,
which I think is worth talking about. But this pertained to the scope of the remedy. So one thing that happened was after these injunctions started to issue, and it was like 26 states plus thousands of schools where these members' kids happen to attend, like that's a lot of, that's a major nationwide patchwork of places where it's really hard to predict what rules are in effect where. And so some people said, well, the Department of Education said, hey, can we scale back the injunction here? Can we say that the injunction only applies to the part of the rule that's being challenged, which is the gender identity stuff? And the opponent said, well, it's true that the part that we're challenging is for the gender identity stuff, but that's in the definition section. And that means every time sex discrimination is used throughout the regulation, the gender identity piece follows it. So you really can't just segment it. So there was a dispute about the scope of the remedy that reached the court on its emergency docket. And the court was like, in our emergency capacity, we are not going to do something so brash as to change the scope of the injunction that was issued. So that was where the Supreme Court had to touch it, but it was not on the merits at all of this decision. So I think probably in the next year we'll see more decisions on the merits that can make their way to the Supreme Court. But it's always hard to predict the litigation timeline.
Yes. Question where? Right here. Oh, yes.
My understanding is that a lot of the controversy right now with the new guidelines, regulations, with the new regulations has to do with athletics. Now, I don't want to open a huge can of worms, so I'm going to, you're chomping at the bit to get to that. So I'll give you the opportunity to either talk about administrative lawmaking, because weren't the sports merely guidance and not regulations? And that's not even been talked about, which is interesting. Or you could talk about how the new regulations impact or do not impact athletics.
Okay, I'll start with that piece. So the Biden administration recognized, I think, rightly, that including a provision of Title IX regulations that answered this question of how women's sports should regulate and accommodate the participation of trans girls and women in women's sports, that was an issue that would be just too big to add on to an already massive rule, and that would be something that would be best addressed in a follow-up rule coming later. And so that's what they did. They kind of said, what we're talking about here is discrimination against trans students in general, but what we're saying in this rule doesn't have any particular bearing on their right to participate in sports. That's going to come down the road later. And what I think is motivating a lot of the litigation now, though, is a preemptory strike against a regulation that would conflict with a number of states that have issued blanket prohibitions against trans girls and women's participation in women's sports, whereas the Department of Education standard that it would likely finalize would be something that requires some degree of participation, or at least a more careful scrutiny than to say, no, never, you have to be, assigned female at birth to play women's sports.
I agree with that chronology of or in summary of what's happened and where it is. My understanding is that there is a political dimension as well, in that this allowing particularly women, persons who are born male but assert a transgender identity as female to play on women's sports teams is intensely controversial, more so than many other gender identity issues. It tends to poll badly compared to other issues involving gender identity, and there was some concern that this would leave Biden and other Democrats vulnerable in midterms and eventually in this year's election. So we'll see what happens on that front.
There's something that the two of you can agree upon. It's controversial.
I mean, of course, the bifurcation of that issue was certainly a political calculation.
Yeah. Other questions? So I want you all to understand, to know that we have 6 o'clock classes here.
Yes, go to class.
As well as
Yes.
The cafeteria is open as well. So we've reached the end of our time. Again, I want to give another round of applause to them. And I want to praise you all as well. This is a wonderful crowd, and you showed the sort of attention and politeness that we expect here, and that you have given us cause to be very proud of. So thank you. Thanks very much.